see if... I think we're... There we go. Good day, Crime Talk aficionados. This is Scott Reich of Crime Talk, and thank you for your patience. As you can see, we're only 25 minutes late, and I apologize for that. That is completely unacceptable. And just when you think everything's ready to go, YouTube adds one more step. So, one of these days we're actually going to get it. So, once again, apologies. We'll try to fix it. And hopefully everybody can hear me okay. And now that we're streaming, we're gonna get rolling here. All right. So my name is Scott Reich. I am a criminal defense attorney here in the state of Colorado. I have done this for some 25 years, and I handle very serious felonies, from murders to sex assaults, you name it. That's what we do. That's my specialty. Anyway, we started this channel a while ago, and what the purpose of this channel was to basically provide a little more in-depth information and discussion as it relates to criminal cases, not only that going on here in Colorado, but around the country. Now, it just seems to be that recently we've had a lot of cases in Colorado. We had the Christopher Watts case, and now we have the disappearance of Kelsey Berreth, and a gentleman by the name of Frazee has been charged in that particular case. So I want to talk to you today about that particular case. There have been some recent developments, literally as of yesterday, and so just for people who are not familiar and who may not have heard much about this particular case, we'll give a quick synopsis, kind of reset everything, and then we will get into it and we will take your chats. Now, first of all, if you like the channel, please subscribe, all right? Obviously, it helps if we can give notifications to people, and if you also like the channel, like the videos that we put up, we really do appreciate it. And so, first off, thank you. Please subscribe. Hit the like button. Okay. So the Kelsey Berreth case, rather interesting. Kelsey Berreth is a single mother. She was apparently engaged to a Mr. Frazee, and at some point they got separated. They live separately. Mr. Frazee lives on a residence with his mother. She had her own apartment, and Mr. Frazee was the last individual to see her alive, as far as what we know, and that's because they were exchanging the child on Thanksgiving, and there was, or day before Thanksgiving, and there was a video camera showing her at the store, and everything seems to be fine. And basically, she's gone. Her mother, Kelsey Berreth's mother, ultimately reports her missing, and it's about I think 10 days later after that she also reports her missing, and the police starts investigating. Interesting fact was that Mr. Frazee said that he was cooperating, but that he was only communicating with the police through his attorney. Now, as I said, I am a criminal defense attorney. I have been a prosecutor. I can look at it from both sides, okay? From the prosecutor side, that's a little weird that he is lawyered up in the sense of the mother of your child is now missing and you're not that concerned about it. You haven't heard from her, okay? He says that he receives a text message a couple days thereafter and everything's fine, and it was reported that a text message from Miss Berreth's phone asked her employer that she needs some additional time off, and that phone pinged or was used somewhere in Idaho, okay? And that takes a little bit of a twist here as well. And so as we go along, the police start doing their investigation, and the police have a press conference and basically say that they are not getting the cooperation that they would like from Mr. Frazee, but his attorney gets out there and says, no, we're doing everything that we're supposed to be doing, and we're just as concerned for Ms. Berreth as you are. And so as things go along, the police ultimately get a search warrant for the residence where Mr. Frazee lives. It's unclear exactly what they took, but ultimately, just prior to the holidays, Mr. Frazee is arrested, okay? And he's arrested and he's charged in a criminal complaint and information. And that particular case number is 18 CR 000330, okay? This is in the District Court of Teller County, Colorado. And Teller County, Colorado is, if you were in Denver and you headed straight south, you would head to Colorado Springs. Once you got to Colorado Springs, you would take a right and you would go probably 60, 100 miles, maybe 60 miles, I guess. It's been a while since I've been there, but it's a couple-hour drive from Denver. And let's face it, it's a very rural community, not a whole lot going on out there in the sense of crimes, not a high crime district, so to speak. And you can tell that by the filing. The case number is 18 CR 330, which means they've had 330 felony filings as of December 28th. So not a whole lot of criminal cases. I think in Denver, if you were to look at a case in 18 CR, it would be probably in the 18, probably 10, 20,000 felony filings easily, okay? So not a whole lot of crime action down there. But ultimately, Mr. Frazee is arrested. He does not continue to retain his private counsel for whatever reason. More than likely, it's financial. Homicide cases are expensive. That's just the reality of it. Why is it so expensive, you say, Scott? Because they take a lot of time, okay? And you never know where things are going to lead, and you have to investigate from the defense perspective everything that your client tells you about, everything that the DAs basically investigate and the police go out and investigate. You have to go and either see if that's true or accurate. Did they leave something out? Or is it exactly the way they alleged? And usually there's a little deviation. It depends on the case. Okay, someone here says, drop in volume. Can't hear me very well. Let's see if we can fix that. Lost sound. Mic changed. Lost the volume. Okay, hopefully people can hear me now. What happened to the sound? Volume went down. Yes, CU Boulder. I'll talk about that in a minute, why I'm wearing the CU hat today. Okay. Sound is 33% of normal. Sound hello. One of these days we're actually going to crack the technical issues that we have here. So I'm going to hold on and see if we can get this. Okay, now it says we're good. Sound is clear. Better. Perfect. All right. Thank you so much. So, as we're talking about, Mr. Frazee gets arrested, and he's charged in a criminal complaint and information, okay? And he's charged in count 1, murder in the first degree, which is a class 1 felony here in the state of Colorado, which carries a possible penalty of life without parole. Now there's an echo. Now we have an echo. We're working on the fact, trying to get no echo. We're working on that. Up there again. Echo now. Echo. Hold on one second. We're trying to fix the echo. Hold on a second. Our technical crew is trying to fix the echo. Echo. Keep talking because they're trying to fix the echo. Shake the mic, somebody says. We'll try that. Better. Good. Reverb. Sound perfect. Okay. Whatever we did, we should probably take a snapshot of that so we know exactly where everything is and that we never have to deal with technical issues again. You would think we would have this cracked. But we're working on it. So first count, count 1, murder in the first degree, a class 1 felony. And it alleges on or about November 22nd of 2018, Patrick Frazee unlawfully, which means without legal permission or justification, feloniously, which means that it is punishable by a possible sentence in the Colorado Department of Corrections, after deliberation and with intent to cause the death of a person other than himself, caused the death of Kelsey Berreth in violation. Now they're saying turn the volume up again. Too low. I got some people saying sounds are great. Echo is gone. Who suggested to shake the mic? Dying of laughter here. Yeah, I should hit it with a hammer, right? It'll work better. Okay, you got rid of the alien. Sound is perfect. Turn up your headphones. Too low. Turn up volume. Good now. Little echo. Really, I don't know, ladies and gentlemen. We are doing the best we can here. All right, so that is count 1, murder in the first degree. It is simply after deliberation that is alleged that Mr. Frazee killed Miss Berreth. Now, what we also know is very interesting in this particular case is no body has been found. And that's, we'll talk about that in just a second. Count 2, solicitation to commit murder in the first degree. It says, between and including September 1 of 2008 and November 1, 2018, I'm sorry, the first one was September 1 of 2018 and November 1 of 2018, Patrick Frazee unlawfully, once again, without legal permission or justification, and feloniously, which means it's a felony punishable by a possible sentence in the Colorado Department of Corrections, commanded, induced, entreated, or otherwise attempted to persuade another person to commit the felony of murder in the first degree, with intent to promote or facilitate the commission of that crime, and under circumstances strongly corroborative of that intent in violation of the statute here in Colorado, 18-3102. So what that comes down to is that they're obviously alleging, the state is alleging that Mr. Frazee asked somebody to kill Miss Berreth. Now, it doesn't say who in this particular count is alleged to have done that, and obviously at some point that will have to be turned over. Count 3, murder in the first degree. It says on or about November 22nd, 2018, Patrick Frazee unlawfully and feloniously, acting alone or with one or more persons, committed or attempted to commit robbery, and in the course of or in furtherance of that crime, or in the immediate flight therefrom, the death of Kelsey Berreth, a person other than one of the participants, was caused by anyone in violation of 18-3102. So what does that mean? Okay, someone here is saying I still can't hear it. Other people are saying it's perfect. I think we're hearing it here okay on this end, but we'll see. What is count 3? Count 3 is what we refer to as the felony murder statute, okay? And basically what they're alleging is that they're saying that Mr. Frazee, with either by himself or with another person, went to commit a robbery, which is basically taking something of value of a person and without their permission. Okay, obviously, if you walk up to somebody and you say, "Give me your money," that's a theft. If you go up and grab their arm and you say, "Give me your money," that's a robbery. If you kind of grab their arm and give some force, or you threaten them, that's also a robbery. If you use a weapon, that would be aggravated robbery, but that's not alleged here. But if anybody dies in various crimes in Colorado, arson, aggravated robbery, and somebody dies in that offense, the perpetrators can be charged with murder in the first degree. Don't have to prove that you intended to kill anyone. They just simply have to show that a robbery took place, as they're alleged here, and somebody died. That's it. So it'll be interesting to see what it is alleged that Mr. Frazee attempted to take from Miss Berreth. That'll be very interesting. Count 4, solicitation to commit murder in the first degree, a Class 2 felony. That carries a presumptive range as a Class 2, 8 to 24, And if it's aggravated or the circumstances are allowed under the statute, it could be 16 to 48 plus a 5-year mandatory period of parole if one was ever sentenced to the Department of Correction and got out. And it alleges between and including September 1 of 2018 and November 1 of 2018, Patrick Frazee unlawfully and feloniously commanded, induced, entreated, or otherwise attempted to persuade another person to commit the felony of murder in the first degree with intent to promote or facilitate the commission of that crime and other circumstances strongly corroborative of that intent. Okay? Now, a couple of interesting things here. He obviously has 3 counts of solicitation, and I'm not going to read the 5th one because it reads exactly the same. Now, the question becomes, did he solicit 3 other people and try to get somebody to kill Miss Berreth, or was it the same person 3 times? We don't know. Why don't we know that yet? Because there's been no affidavit released, okay? When one is charged with a crime, if an officer sees a crime take place in front of you, or they believe that they have a crime, they witnessed it, or they have probable cause to arrest you, they can arrest you without a warrant. But if they really don't see it and observe it, they need to get a warrant from a judge, and they fill out an affidavit for an arrest warrant, okay? And that affidavit has to include kind of the good, the bad, and the ugly of their investigation, all right? If they have witnesses that said something but they're not credible, you have to put that in so that the judge has all the information. Okay, somebody here is saying that there's iPhone and Android and they're both low. I wonder who the people are that are soliciting. I agree. That's very interesting. But like I said, we're talking about the affidavit here, okay? And so the affidavit for arrest warrant is going to lay out the information why they believe that Mr. Frazee should be charged with murder in the first degree, 3 counts of solicitation, and felony murder, okay? Normally that is public information. Normally the district attorney, United States attorneys will hold off on having that information released if there are multiple co-defendants or something along those lines. And what's taking place here is the district attorney actually requested that it remain sealed so that they could continue their investigation and basically not tip people off and things of that nature. However, obviously the defense is entitled to that information, and the defense demanded that. And what took place on Friday was that the courts agreed to a protective order. And basically what the protective order does is says that the affidavit can be released to the defense so that they can start preparing their defense, because obviously that would be unfair if you don't get to see the information that they have against you, your client. And the protective order, and I have not seen it, it's not public information, but basically it'll say that you can't turn it over to anyone unless they are associated with this case, i.e. other attorneys, investigators, something along those lines, okay? So now the defense can start doing that. They can start investigating. They can start seeing what they have, and hopefully some discovery has been turned over to them, because Mr. Frazee has a right to a preliminary hearing within 35 days of the official filing of charges, okay? And they were, all the parties in this case were set to appear on Friday. They were going to set a preliminary hearing date. And by statute, and if you remain in custody, you have a right to a hearing within 35 days. Why 35 days? Well, because we don't want people lingering around in custody if they've done nothing wrong, okay? And the defense can waive that, and the DA can ask for good cause, but normally the defense asks for it and says, hey, we need more time to investigate. We need to see what the hell is going on, okay? And that's what the defense did on Friday, and they set the case out, I believe, until February 19th at 9 a.m. That'll be the preliminary hearing, okay? Preliminary hearings, are they that big of a deal? Not really, okay? Most cases don't go to preliminary hearing. Some do. In a homicide case of this nature, my guess is it's going to go to hearing, okay? And what does the district attorney have to do? Do they have to show their entire case at the preliminary hearing? Do they present everything? No. What they will usually do is put up one witness who will be the lead detective, and he will get up and regurgitate what he put in the affidavit for arrest warrant that was signed by a judge that got Mr. Frazee arrested. Okay? All they simply have to show is present some evidence as it relates to each and every element of the offense charged, and the case will be bound over. The evidence has to be viewed in the light most favorable to the prosecution, drawing all inferences in their favor. Okay? I can tell you in 25 years of criminal defense work, the number of cases that I personally have had thrown out at a preliminary hearing, 1. Okay? And that's simply because I asked a witness on the stand, what evidence do you have that my client knew that the shank was in this particular mattress? And the detective responded, nothing. And everybody just kind of stood around. It was one of those Perry Mason moments. And I sat down and I, rested, and the prosecution rested, not realizing what's going on, and the judge dismissed the case. Okay? So is this case going forward after the preliminary hearing? Yes, unless they cannot present some evidence as it relates to that, okay, as it relates to each and every element. Each element are, let's say, murder in the first degree. They have to show that it was Patrick Frazee, not someone looked like him, not someone using his identity, but him, okay? Now, unless there is a complicitor or someone that acted with him lately, and the district attorney can always amend these charges later, but they have to prove that it was him, okay, Mr. Frazee that did this. And obviously he had no legal permission or justification. You can't go around killing people, and you can kill people if it's justified, like if they're attacking you with a weapon and you have no other recourse, you can use deadly force, okay? But they have to show that Ms. Berreth is deceased, okay? Now, the district attorney is holding their cards really close to their chest in this particular case because they believe that she is dead, okay? But they have no body, okay? Can you prove a murder case without a body? Yes, you can. Is it a hell of a lot more difficult to prove a murder case without a body? Yes, it is. Why? You have to show that she's dead. Bottom line. Think about it, right? So, I don't know. I was trying to think of it where I could find a video clip of it, but I can't remember if it was like a Perry Mason case or Matlock or something along those lines, and it's a murder case and there is no body. And the defense attorney gets up and says, in the next 30 seconds, the victim in this case is going to walk through those doors, and everybody's head turns to the doors, and they wait, and nothing happens. But then the defense attorney looks back and said, but you looked. That's reasonable doubt, okay? They wouldn't say, no, we're not going to look because she's dead, right? They have no body in this particular case. It's going to be pretty difficult to prove unless there is a confession, if there's a text message, some sort of admission, or somebody that he has, like I said, made a confession to. Not just to the police, it can be to anybody, whereby they allege that he said that he killed her, all right? And now, obviously, if there's an accomplice in the case, that'll always be interesting because somebody always rolls in an accomplice case because they start looking at life in prison and they're like, man, this is what I signed up for. I'm rolling on that guy to cut me a deal. And the reality of it is, from a prosecutor perspective, that's a good thing. We want justice to prevail, right? And sometimes justice is the bad guy, goes away. It's I always get asked this question: how can you represent guilty people and they're guilty and they get off? Okay, the defense didn't win. The prosecution failed. The burden's on the prosecution. Okay, and if the prosecution fails to prove that case to each and every element of the offense charged beyond a reasonable doubt, the defense doesn't win. The prosecution has failed. Okay. So I get that question all the time. How do you do that? It's easy. It's easy. You're holding the government to their burden of proof. It's required under the Constitution of the United States of America, and you take an ethical obligation when you become an attorney and represent a client to zealously represent them, okay? Bottom line, that's it. So those elements, how are they going to do it without a body? It'd be very, very interesting to see, and we'll see what takes place shortly, okay? So there's been information, obviously, that the cell phone of Ms. Berreth pinged in Idaho, and she had family there. Okay, so obviously, if you're a defense attorney, you're going to say, well, she's obviously out there. She must have dropped her phone hiking with family. Who knows? Maybe she, even if she is dead, she must have hit her head and died of natural causes. You never know. Because even without a body, you can't have a coroner get up there and say this is how the person is dead. Okay? So short of a confession, the prosecution in this particular case, or some other information, obviously we don't have all the information, but also understand it takes a very low standard of proof to arrest somebody, okay? And my kind of gut feeling here is the prosecution still doing their investigation, and I'm not sure they have enough to really keep it going. I think they arrested Frazee, threw him in custody, see what we can do, try to sweat some other people that they think he may have had contact with, and we'll see. Unlike Mr. Watts, Mr. Frazee from the defense side has done absolutely everything perfectly. He has kept his mouth shut, okay? Kept his mouth shut. That's huge, okay? Because anything he says can and will be used against him. And that means misconstrued, misinterpreted, taken out of context. So the less he says, the better. Hopefully, and I know his attorneys have probably told him while he sits in that jail cell not to talk to anyone about the facts of his case, because the only thing worse than somebody cooperating from the defense perspective is a jailhouse snitch cooperating, okay? Jailhouse snitches are not normally reliable at all. So they're just usually not good people in that regard. It doesn't mean they're not telling the truth. It just usually means they've got some bias. Nobody particularly likes them at all. Okay. Tim or Mike, please raise the gain on Scott's mic about 30 degrees. Is that this one right here? How's that? Let's try that. All right. So here we go. No body, preliminary hearing set for February 19th at 9 a.m. Will the prosecution have enough to go forward? We will have to see. Now, the phone, we're talking about the phone. It's pinged. Now, there's been reports that there is a nurse in Idaho that apparently was married, allegedly, got divorced to be with Mr. Frazee, and apparently friends and things of that nature, as it's been reported in the press, that this nurse spent time in Colorado over the holidays, been out to see Mr. Frazee, and so there we go. It's going to be interesting. That woman's name has not been released as of yet. It'll be curious to see what, if anything, she knows. It'll be very interesting to see if she did have something to do with it, if she keeps her mouth shut, if she's ultimately charged. Now, remember, if the prosecution had enough to charge an accomplice at this point, they'd have done it, okay? They would have done it, which means they don't have enough, okay? So they just don't have enough at that point, which makes me think the district attorneys are biding their time. They don't want the information that they have or they investigate further to get out to the public and people talk or not talk. It's going to be very interesting because it starts rumors, which is what next thing I want to talk about is some of the motions that have been filed in this particular case. Okay? So that's kind of the charges, the elements, and the background. All right. Now, last time we talked about this case, we had a judge who has since rotated out of the courtroom, and it was a normal rotation. And let me get her name here again. I forgot it. I've actually appeared in front of her. It was Judge Linda Billings Vela. She has rotated out, and we have a new judge now. Give me 1 second. I lost my spot with his name on it here. The new judge here in Teller County is Judge Scott Sells, S-E-L-L-S. And I did some research on him last night, and although I've never appeared in front of him, he was up for retention here in Colorado last time, and the Colorado Judicial Nominating Committee sends out questionnaires to judges, to attorneys, litigants in the case, so defendants, things of that nature, plaintiffs, defendants, if civil cases. And basically, they see if, is the judge competent. He received exceptionally high scores. 70 to 80% of attorneys said he was qualified, clear in the law, basically a good judge. Okay? So once again, we have a good judge. And that's a great thing. We have very good judges here in the state of Colorado. All right? I'll be honest with you, a little secret. There's a couple, maybe fit 5 on a hand. Okay. Maybe you can fit five judges on a hand that I would say not great judges, but they usually get voted out. Usually, sometimes they stick around. But for the most part, the judiciary here in the state of Colorado is exceptional. All right. Thank you for all your coverage you've done. Thank you, Megan Cunningham, for the $5 super chat. Appreciate that. And I guess I should mention that. I guess the super chat thing is here so that a lot of these comments are rolling by. So while I'm talking, it's try to watch these and talk and read them and do whatever. But when they are a super chat, they get highlighted. And so you guarantee that I will be able to see it and take your question or give you a big shout out there. So thank you, Megan. So we have good judges here. There's no reason to believe that these judges here will not be great and give all parties a fair trial, which is all you want. I have told clients over the years, even when we lose a trial, and it happens, I know, we lose every now and then. But when you do, the best thing that you can tell a client is you had a fair trial, okay? There have been cases where I have had to look at my client and say, you got screwed. The judge did not give you a fair trial, and it's unfortunate, but I only the remedy then is to do an appeal. But when you have a fair trial by a fair judge who simply calls balls and strikes and is not trying to get to any particular result or outcome to satisfy their own desires, that is a good thing, okay? And I have no doubt to believe that as of right now, we have a very good judge for this case. Both the prosecution and the defense will receive a fair trial, and the judge will literally be up there calling balls and strikes, okay? That's all they're supposed to do. Consider a judge as an umpire. He is simply supposed to go out there, call the game, doesn't care who wins or loses, just calls balls and strikes. Now, that doesn't always happen. There's obviously biases in everybody, and they don't want the bad guy to go free sometimes. But that's not their job to make sure that happens, okay? So let's talk about some of the motions that have been filed in the case. The first one, and these are rather boilerplate. Joe Can, thank you for your time and experience. No, thank you for tuning in and subscribing, Joe. I appreciate it. I appreciate everybody that subscribes. I don't know if you all have noticed, but we have literally jumped about 20,000 subscribers in the last couple of weeks, and I appreciate that. I'd like to think that we're doing something right that people are interested in, and we will try to continue to do that and to do it better every time so that we don't show up 25 minutes late when we say we're going to be there. That's just rude, and I apologize again. All right, so a couple of the motions that have been filed. A lot of these are very boilerplate, okay? Here in this case, the public defender's office is representing Mr. Frazee, okay? And whether it was a public defender, privately retained counsel, or if it is, what they call out here in Colorado the alternate defense counsel. These motions will be in fact filed in just about every case. Okay. Am I pronouncing it Lisantica?
Toss out some of your gut feelings too. Those are always insightful. I will do that. Okay. Well, my gut feeling is I think everyone's going to get a fair trial at this point. I have no reason to doubt that whatsoever. And so the first motion to preserve, motion for preservation and production of law enforcement notes, recordings, and other evidence. Okay. Now, why would this case be filed, right? Obviously, the prosecution has to turn over everything that they have. The prosecution, there's what they refer to as Brady material. It's a case, goes back many, many years. Brady B. Washington, I can't remember the name, but Brady. It's Brady. That's what everybody calls it and refers to it as. And if the prosecution has information that is beneficial to the defendant, they have to turn that over. Bottom line is, prosecution has to turn everything over to the defense when they get it. There can be no delay or anything of that nature. But in this particular case, the police are asking, obviously, or the defense is asking of the police to turn over all investigative videos, notes, transcription, anything that's taken place, any recordings, 911 calls. And as we saw in the Watts case, and hopefully that was informative to, thanks for viewers. Thank Aratria, I hope I pronounced that correctly. Thanks for reminding viewers of the presumption of innocence and insight on how the rule of law works. That is one of the goals of this channel, is to be able to explain the law and provide a little more insight and a little more information that you get on the evening news. Okay, it's my pet peeve when I watch the evening news and a reporter doesn't know the difference between a preliminary hearing and an arraignment, because they're two completely different things. All right. So jumping back to the motion, the defense has filed a motion basically saying preserve everything. Any exculpatory material, anything that's discoverable under the 5th, 6th, and 14th Amendments to the United States Constitution, as well as the applicable and appropriate sections of the Colorado Constitution. And I'm sorry, it was Brady v. Maryland. That's a 1963 case where the Supreme Court actually had to rule and say, hey, prosecution, you have to give everything to the defense. Can you believe that? Somewhere along the line, had to go all the way to Supreme Court for them to say, prosecution, give the defense what you have. Even if it's hurts your case, you still have to do that. Why? Because that's justice. What's the role of the district attorney? To seek justice, not just to get convictions. All right? Ryan W., thank you. $10 super chat. Wow. Thanks for the superb coverage, Scott. Articulate and above all objective. That's what we try to do, trying to keep it objective. I could argue either side of any one of these cases either way. We're going to try to give you both sides so it gives you something to think about, and then we can talk about it, okay? So that's what we had to do. And, of course, the prosecution responds and basically says, hey, we have no objection to the preservation of notes. We'll provide anything, we'll do what we need to do. And the court then has issued an order because the district attorney wasn't thrilled about any existing notes. And the judge said, at the advisement hearing, the prosecution did not object to notifying law enforcement to preserve existing notes and recordings involving this case and otherwise comply with their Rule 16 discovery obligations. However, they objected to parts of the defense motion that were overly broad, overly burdensome, and infringe on work product. On December 21, the court orally issued an order requiring the prosecution to preserve existing handwritten and recorded law enforcement notes involving this case. This court stated it would address the remainder of the defense motion at a later date. Okay, why does that matter? All right, Stephanie Burrows, thank you very much. $9.99 super chat, thank you very much. So what this comes down to is when officers go out and do an interview. Now, a lot of times things are videotaped these days, particularly in serious cases. They call the witness down to the police department, they interview them, there's a body cam on them or something along those lines. But not so long ago, only a couple years ago, body cams weren't that prevalent. Video interviews weren't done unless it was a serious felony case, in the sense that they were recorded. And so the officer would take notes. He would take little cryptic notes, and he would write this information out, and then at the end of his shift, when he's preparing all his paperwork, he would then type up his report and then shred his notes. Okay? Now, you would think, maybe it's just me, but I would think if I was doing something, part of my job that required me to preserve things and have the best memory that I can at the time, I would obviously want to take notes, but I would also want to preserve those notes. Okay? So you have to basically ask the court to tell the DA to go to the cops to say, any handwritten note you take from this point forward, any emails back and forth, you have to save that. Why is that important? Because it happens all the time where you read a summary, a result of interview from a police officer, you compare it to the notes, and they left something out, okay? In this day and age, now we get video everything. I feel like I spend half my time of my life watching video of other people do video, okay, of asking other people questions. And what is curious, though, is the police officer will do his nice little results of interview. It's one little page. It's nice and neat. But the interview went on for 4 hours, okay? And they're like, here's the highlights. Well, it's a highlight for the prosecution. They don't tell you the good stuff, like the client said I wasn't there, I have an alibi, couldn't have been me, I don't know this person, what have you, okay? So you have to go through and basically verify what's there. In the words of Ronald Reagan, trust but verify, okay? That's why the defense is so expensive. You get hundreds, thousands of hours of video, and you have to watch it and compare it. And it's sometimes you don't grasp it all in one particular time. It takes multiple watchings of it. You have to have transcripts prepared, which are expensive. Criminal defense is expensive. And to get a top criminal defense attorney, it's even more expensive because you're going to need a team of attorneys, okay? It's just better. It's been a long time, probably 15 years since I did a homicide case solo. It's just better the more people. You need a whole team. Nothing gets done in the criminal defense world today without a team, whether it's prosecution or the defense. Whether you're the person up front answering the phones, filing, that is just as important to get that discovery in the right file as it is for me going to court and try to sound articulate and not embarrass myself or my client, okay? It doesn't matter. Same thing when you fly in an airplane. The guy that flies it is no more important than the guy that pulls the chocks and says everything's good to go down here on the ground. It is a complete team effort, okay? But the judge actually has to order them to do that because the DA didn't want to do that, all right? Which is always a little bit beyond me. The public defender also filed a motion basically saying, hey, we're appointed. Don't do any Rule 41-1 examinations of my client without us being present, okay? What's a 41-1? Okay, the police just can't come up and talk to you and say, I want your fingerprint once you're represented. You have to have counsel to do it. In fact, unless you consent, they have to go to the court to get permission to do so. And here in Colorado, it's a 41-1, okay? And you have to show why it's relevant, why they need it, et cetera, and then the judge will usually grant it. And there's not much on the defense you can do, but the defense was giving notice of that, and the district attorney didn't have a whole lot of problems with that. So here's an interesting motion. Motion for preservation of physical evidence, all right? Why is this important? There's been information reported that there was going to be consumptive testing of some type, okay? What is consumptive testing? That means that in the process of testing it for example, DNA evidence, DNA can be very small. It's invisible. You can barely see it sometimes. But to test it, you still need to use part of it. And if you use that, you have to give notice. If you consume it all and it can't be, the defense doesn't have an opportunity to look at it, inspect it, do their own testing, you have to let the defense know that you're going to do that and that they can have their expert available standing by watching the procedures to see if anything was done incorrectly or it was all done fine, okay? Thank you, Donna Heflin, for subscribing. Thank you for the super chat. I appreciate it. Thank you, everyone, for subscribing. Thank you. Like the channel. please subscribe. We appreciate that. All right, so preservation of evidence, that's important. In this particular case, the district attorney wanted to do consumptive testing, and the defense said, no, we want to wait because we need to see what we're going to do. The district attorney withdrew their request to do that consumptive testing on Friday, basically realizing or figuring out what they had no longer was necessary for them to do that. So as it relates to that, testing is no longer an issue. It's moot, okay? Now, no longer there for the court to consider. The court did consider it and basically said, if you are going to do any sort of consumptive testing, you have to let the defense know they have a time to inspect it or do their own testing, okay? That's super important because, once again, why? Why should we just trust the government that they're doing a great job? Think of all the cases, all the crime labs where you hear about a lab technician, fingerprint somebody, just phoning it in when it comes to doing their test and saying, yeah, it's a match, it's, and they falsify stuff. That's why the defense is there. Trust but verify. And sometimes the police do it right, okay? They get it right a lot of the time. And there are many, many, many good police officers, great police officers out there. I just wish when the bad ones came around, the good ones would tell the bad ones to go away, but they always seem to fight to the bitter end because they think if they give up one, they got to give up all of them. And that is, it's frustrating. The other motion that was filed by the defense was notice of invocation of all statutory case law and constitutional privileges, okay? Obviously, when you're represented, the prosecution and the police investigators cannot go to the jail and speak with Mr. Frazee and say, hey, we would like to ask you a couple of questions, okay? So they're invoking an attorney-client relationship. You can't go talk to them. If there's any medical privileges that exist where Mr. Frazee's consent is required, the defense is putting the prosecution on notice that you can't do anything about that unless and until you get court permission, i.e. either a subpoena or something of that nature. Now, the court issued an order, which it's kind of standard, but I think it lays it out. And for most people that don't deal with this on an everyday basis, that's why we're trying to do this channel. I hope you all enjoy it. It's not boring. It explains why, what the prosecution can do. It says prosecution acknowledges the defendant has the authority to invoke his medical privilege for all medical and psychiatric, including drug or alcohol treatment privileges. Therefore, the prosecution shall, which is mandatory, shall not seek to obtain such privileged records. However, the court finds the defendant may not have the right or authority to invoke all privileges in school, military, probation, prison, social services, or other records in which the defendant has a confidentiality expectation. All right? And then it gives some relevant Colorado statute and federal applicable statute as it relates to Freedom of Information Act, Criminal Justice Acts, things of that nature, whereby that privilege won't apply. But once again, it's putting the prosecution and everyone and the police department, investigators on notice. You can't just go get Mr. Frazee's records out there. There's privacy interests. Just because you're charged does not mean that you waive those rights, okay? You can waive any right you want. You can waive your right to jury trial. You can waive your right to counsel, but it has to be a knowing, voluntary right to do so, okay? Now, this is probably my always favorite one, and that's the motion to limit pretrial publicity. I've filed this motion. I've opposed this motion. It just depends, all right? And the public defenders filed a motion to limit pretrial publicity. Well, they can't do that, all right? And they allege and argue that Mr. Frazee is guaranteed the right to a trial by jurors who are fair and impartial. Absolutely agree. Everybody would agree with that principle, I would hope. If not, that's a little scary. Thus, while Mr. Frazee is not entitled to jurors who will be sympathetic to him, he is guaranteed the right to a trial by a juror who will hear the matter fairly and impartially, okay? That's the requirement. Can you be a fair and impartial juror Basically, listen to the evidence, reserve judgment till you hear all the evidence, follow the court's instructions, and be able to deliberate peacefully with your other jurors. If you can do that, you're qualified. Does it mean you've heard something about the case, you're somehow disqualified? No. And let's face it, ladies and gentlemen, the press oftentimes gets it so wrong. I have had cases where they've been covered by the press. I read it in the newspaper, and I literally wonder, were they at the same hearing that I was at? Because nothing that they said happened, or what they wrote happened or occurred at all, okay? So only thing that matters is for a juror to be able to say, I'm going to listen to the evidence presented from that witness stand, and evidence that's been legally admitted to be considered, okay? And then it says, because of the massive pre-indictment and pre-trial negative publicity, this order is necessary to preserve and protect to any extent that might be possible at this stage of the proceedings Mr. Frazee's right to trial by jury and right to a trial by fair and impartial jury, okay? I don't think there's been a ton of negative publicity. I think there's been publicity, but I don't think there's anything negative about it. It's been the facts that have been published. Mr. Frazee's been arrested. His home was searched not once, but twice, maybe even 3 times, I believe. And now he's in custody, okay? He's been charged. Doesn't mean he's proven guilty. There is a presumption of innocence, and that's it. The prosecution, of course, responds, says, no, there's no need to limit anything. So that's it. TJ, appreciate the breakdown of how the legal field works. Great channel. No, thank you, TJ. I appreciate you and everyone that watches and subscribes. The court issued an order the other day. This was actually filed December 31st, but it was by Judge Billings Vela, who's, as we stated, has rotated out back to El Paso County. And it's pretty straightforward. And it says the courts considered the motion, the prosecution's response. The parties are ordered to strictly comply with the rules of professional conduct, specifically 3.6 as it relates to trial publicity, which states a lawyer who is participating or has participated in the investigation or litigation of a matter shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in this matter. Okay? What does that mean? When a lawyer walks out of the courtroom, can he simply say, the evidence is insufficient, my client maintains his innocence? Absolutely. Now, can he come out on the court steps and say, there's so much information that you don't know, and these people are not being truthful, and the truth will come out? Possibly. But most attorneys, I think, take the general position you're not going to go try your case in the press. Now, sometimes you can, and there's a couple here in Denver. They're great attorneys, and they are masters at using the press. But you have to do it ethically, okay? But it says, notwithstanding the paragraph of Rule 3.8, thank you, Amanda Hart. Keep up the great work. Thank you. Keep subscribing. Keep watching. It says the lawyer may state the claim, offense, or defense involved, and except when prohibited by law, the identity of the person involved. So if it's a minor or a victim of sexual assault. Information contained in the public record. They can talk about that. That investigation of a matter is in progress. The scheduling and result of any step in the litigation. A request for assistance in obtaining evidence and information necessary thereto, which would be, if anybody knows where this person may be found, we believe they're the key to the case. They can ask that. Once again, criminal cases, in addition to subparagraph 1 and 6, the identity, residence, occupation, and family status of the accused. The accused has not been apprehended. Information necessary to aid in apprehension of that person. The fact, time, and place of arrest. The identity of investigating and arresting officers or agencies, and the length of the investigation. All right? And so those are things that they can and what they have to limit it to. But it's pretty straightforward. You can't get up there and basically, as lawyers, can't lie. And I know a lot of people think that lawyers get up there and lie. Okay? They're not lying. They can't. It's unethical. Do people do it? Yes, they do. And it's wrong, okay? It's wrong. They shouldn't do that. And good lawyers aren't going to lie, but they can get up there and say, my client maintains his innocent, the prosecution has to prove it. okay? Because the client is innocent until and if proven guilty, okay? Let's see. I am telling you, Frazee is smart. We'll see. Yeah, I don't know if it's going to be a hung jury. We're too early in this particular case. But as in the Watts case, who called it first? When they said it for a scheduling or a status conference, who called it? Go back and look. It was this guy, okay? I think, I hopefully will be able to provide that information that nobody else knew. Everyone thought it was going to be a scheduling hearing, and I said, hey, it's a possibility. It could be a scheduling issue, or he could be pleading guilty. Oh, guess what? In Watt's case, he pled guilty. So, yeah. Lanky Jen. Yes, lawyers do lie. Okay, I agree. Some lawyers do, but they're not supposed to. Okay, you can't lie to the court. You can't lie to your client. You can't make misrepresentations to somebody else on the other side. You can say, nope, that's not true. We'll look for it. I'm going to hold the government to their case. Oh, great question, Isa C. Why no bail? Okay. So when you're charged with first-degree murder in the state of Colorado, you can be held without bail. Okay, that's simple, and that can be addressed either when this first gets arrested, or usually by the preliminary hearing, maybe a arraignment stage of the proceedings. Okay, but in Colorado, you can't be held without bail indefinitely. So there's a hearing that has to take place, and the district attorney should, in the next couple of days, if they think they have enough evidence, which we'll see, they'll file a motion for a proof evident presumption great. And what that means is that we want to hold this person without bail. Why? Because the proof is evident. Basically, there's overwhelming evidence, and the presumption is great that he will be convicted. That basically it's so overwhelming. You know, when you got a homicide case and, a guy confessed, it's on video, those types of things. I've had clients held without bail. Proof evidence, presumption, great. I've won those trials, even though everybody said, you're going to lose. I've had other cases where someone's been charged with murder, and they were given a $50,000 bond. Okay? It just depends. It just depends. And so that's why Mr. Frazee's being held without bail is they haven't addressed bond just yet, okay? And you can't just keep addressing bond over and over again just because you're in custody. You have to have changed circumstances. It has to be something other than just the passage of time, okay? But Mr. Frazee, and it hasn't been filed from what I've seen, nothing's been filed for a proof evident presumption great. And that means if the prosecution doesn't, that means that they believe that Mr. Frazee should get a bond. They'll probably ask for a high bond that he couldn't make, and it might as well be a no bond. But that is why they do that. Okay, it'll be curious to see if that's filed. Normally, it would be filed kind of by now. So I'm a little surprised that they haven't done that just yet. All right. And the other motion was the defense and the prosecution both agreed to rescind their motions as it related to the production of the affidavit for arrest warrant. The affidavit for arrest warrant will be released here shortly. It has to be. That's simply the case. Other interesting tidbits in this particular case. Obviously, there has been a what they refer to as a dependency neglect matter. The child of Ms. Berreth and Mr. Frazee is in the custody of the Teller County Department of Human Services, and that will remain as such for some time, okay? Looks like all the grandparents have lawyered up and are seeking custody. There's other family members trying to get involved, and there's going to be a hearing later in February on that particular issue. But right now, no one has temporary custody, but the child is in the custody, physical custody of Miss Berreth's mother, and my guess is it will probably remain that way for some time, okay? And the court's also issued decorum orders. This case is going to be interesting, ladies and gentlemen. We thought the Watts case was going to be interesting, and then he pled guilty. That's the way things happen in life. But this one I think is going to be just as interesting because, frankly, I don't think that Mr. Frazee is going to plead guilty to anything anytime soon. I'm not saying he did anything wrong, but this guy seems like a pretty cool cat and doesn't seem to be too worried about much of anything as it relates to being arrested, walking in and out of court. He doesn't look particularly nervous at all, and I think this case is going to go to trial. Who knows? It may not even go to trial if the prosecution can't do it. Like I said, can they do a case without a body? Yes. I think it'd be very, very, very difficult to do so. All right. So we're going to just about wrap it up. Once again, thank you for watching today. I apologize, and hopefully we're going to get this thing figured out so we're never late again if we go live. And we're going to be putting up content on a regular basis. I appreciate you all watching. I really do. We're doing our best. This technology stuff can be complicated for some non-technical guys or a technical guy like myself, but we're working on it, all right? And so we're going to wrap it up. I appreciate that. One thing I wanted to talk about, today I have on a CU hat. And the reason I had this hat on is that I had to go back and forth to, of all places, Nebraska, for probably one of the greatest CU fans ever existed, and someone very near and dear to me. Her father played at the University of Colorado many years ago, Roger Lindwall, and he was a living legend. Has his brick up there and everything like that. So, unfortunately, he passed away after a long illness, and the family thought it'd be nice at his memorial to have hats with his name on it. I'm not sure if you can see it on this side. This side? No, I guess it's the other side. This side here.
Yeah. Anyway,
so we did that. And we thought it was kind of a nice gesture. All the family and did it, and I was privileged enough, although not technically a part of the family, to be asked to wear one as well. And so I was truly honored by that. And then, unfortunately, this person was near and dear to my heart. Her mother passed away a mere 23 days after Roger did, and that was Sandy. And they've been married, I think, 63 years. And although she passed away as a result of some medical issues, I'm convinced it was she died of a broken heart. They've been together for 63 years, and we're just an amazing couple. I wish I got to know Roger before he got sick. But anyway, so that's why I wore the hat today. I just wanted to say that, and just, hope you're doing okay, Kristen. And so that's it. Thank you for watching. Thank you for tuning in. Thank you for your patience. We do that. Please subscribe. Want to thank everybody that's helped today. Abby, Mike, Pascal. This, like anything in the practice of law, it's not done by one person. It is a team effort, I assure you. And I thank you all for doing it. I appreciate it. I'm very humbled by the fact that we have as many subscribers as we have in such a very short time. I'd like to think that we're doing something that people like, and I don't take it lightly that people have subscribed, so I feel a great duty to try and produce something of quality and get that out to you on a regular basis. So thank you. Have a wonderful weekend, start of the first full week after the holidays. So Happy New Year. Thank you very much.